Hello, this is Timothy Daniels here again with Tim Daniels Law Services. Today I'm going to talk briefly about the statute of limitations, or the time for reporting a workers' comp injury. And if you don't report within that amount of time, then your case will likely be barred, which by the statute of limitations is the time frame in which you have to take action. So when you get hurt at work, you have 180 days to report that injury. You just can't report it to anyone, however. It needs to be reported to the Labor Commission or to your employer. Reporting your injury to the doctor doesn't count. Now, perhaps the doctor will do what he or she is legally required to do, and that is file a Form 123, Physician's Initial Report of of a Workplace Injury. They're supposed to file that within 7 days with the Labor Commission. And in that way, the Labor Commission can receive notice of your injury. And the Labor Commission tracks injuries. They count them. And they make a report each year. It's an annual report about how many injuries are we having in Utah on the job and that type of thing. But it's wisest to report it to both the Labor Commission and the employer. And most people, of course, report it to their employer. But there have been cases where the employer will not want to be involved in a workers' comp situation. Generally, employers do not like workplace injuries. It's a hassle. It costs them more money to get those injuries and accidents resolved. And so it has happened, perhaps a time or two, that the employer will say, oh no, we never heard of any accident. He never reported it to us. And so that's why I say go ahead and report it to the employer, but just to be on the safe side, report it to the Labor Commission as well. One thing, sometimes injured workers don't know if their injury happened on the job. This can especially be true with occupational disease claims. For example, you might have a coal miner or someone who works in an open pit mine breathing in silica dust for many hours and days and weeks and months and years. And when does their 180-day clock start ticking? It's once they knew, or reasonably should have known, that they had a valid claim. So typically that's when they go to the doctor and the doctor says, yeah, you're having breathing problems? Well, what have you done for your career? Oh, I've worked in a mine, really for 30 years. Okay, well, it looks like you've been now diagnosed with black lung or pneumoconiosis or silicosis. And at that point, that's probably when the clock is going to start ticking, because the injured worker at that point knows, or reasonably should know, okay, I probably need to do something about this. This happened on the job. I've had a workplace occupational disease. So again, the standard is 180 days, but please don't wait 180 days. Please report things promptly. And if you have any questions, if you're not sure, then call an attorney, look at a blog or something, get some more information. Please reach out for help, though, and don't press forward in silence, and things will typically work out better. Again, this is information that is on my blog at utahlionlaw.com or timothydanielslaw.com. And I hope this is helpful. Thank you.